Hello, my name is Andrew Kenny. I'm a Social Security disability attorney at Hoglund Law Offices based out of Minnesota. I do work nationally. I do Social Security disability hearings full time. I have for at least the last 20 years. And I started this work in 1992. Today, I wanted to talk about the medical vocational guidelines, or what we affectionately call the grids. I'll get right into it. When Social Security evaluates a case and people have physical limitations, the ability to stand and walk, lift, and carry objects, they look at age. If someone is age 50, between age 50 and 54. If a person is limited to sit down work due to problems such as a low back issue, etc., then the question is, can they do their past kind of work? Social Security looks back to the last 5 years. There isn't a question of doing any other work, just past work. If a person is 55 and older, then the question is someone limited to lifting no more than 20 pounds due to problems? Again, maybe a neck problem, a shoulder problem. If that's the case, the question is, can they return to their past kind of work with those limitations as of age 55 forward? The main point is that when someone hits age 50 and 55, Social Security is evaluating whether a person can return to their past kind of work in the last 5 years. If someone is under age 50, you could still be approved. There's no problem with that, but a person would need to prove however they're limited to sitting work, work on their feet, that they can't return to not just their past work, but any other work. So the standards ease up when someone hits age 50, and rightly so, because at some point, at some age category, people aren't to learn new jobs. So the idea here is that if you're approaching a hearing, and it's good to have an attorney, you can discuss with the attorney what the issues are with age 50 and 55 if they apply. What I commonly see is someone might be 49 when they apply, which is fine. Once they turn 50, and that might have been when your case was pending, we might adjust the start date of disability to line up with age 50. That would affect back pay if approved, but we have a different legal standard coming into play after an application. That's called amending an onset. Your attorney would discuss whether you should argue that you're disabled before age 50 or after. And again, age 55 is another one of those categories where your attorney may or representative may adjust the start date of disability. So there are some changes that can happen if with your case to use that beneficial legal standard. If you're not 50 yet, that's okay. I hear clients say that if I'm not 50, you can't be approved. That's not true. You certainly can be. But the standards ease up when you're age 50 and age 55 with physical problems that limit you. Hopefully that helps. And if you have any other questions, feel free to call our office. We'd be happy to talk with you.